All right, guys, buckle up because this courtroom exchange takes a turn almost immediately. What looks like a routine criminal hearing quickly becomes a showdown over courtroom authority, legal procedure, and a strategy judges across the country have seen time and time again. One man insists his appearing as an attorney in fact, while the judge refuses to let the hearing drift away from established law. As the tension builds, you'll see why the court repeatedly draws a hard line between legal arguments that carry weight and those that simply don't apply in criminal proceedings. Pay close attention, because every response from the bench reveals how judges protect the integrity of the courtroom. And by the end, ask yourself this: was this a clever legal strategy, or did it only make the defendant's situation even more difficult?
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error.
At this moment, the judge carefully reviews the document instead of dismissing it outright, giving the argument a fair look before reaching a conclusion. That matters because courts are expected to consider filings before deciding whether they have legal merit. But as the document leans on civil concepts and broad constitutional claims rather than criminal law, the judge signals that the filing doesn't address the actual charges before the court. It's a reminder that citing legal language isn't enough. The law also requires the right authority for the right type of case.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today.
Here's where the hearing becomes especially significant. The judge directly identifies what he believes is a sovereign citizen-style argument and explains why. In his view, it has no legal effect on the criminal proceedings. Instead of debating every claim individually, he focuses on a central principle. Criminal courts derive their authority from statutes and constitutions, not from documents challenging the court's existence. It's a decisive moment that shifts the hearing away from theory and back to the defendant's legal obligations.
Trial by jury with jury.
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you are wasting valuable time that all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this. And I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter.
Notice how quickly the judge redirects the conversation after another interruption. Rather than allowing the hearing to become an endless debate, he emphasizes courtroom order and reminds everyone that many other cases are waiting to be heard. At the same time, he explains that the trial won't be postponed because of the legal arguments raised, but because of his own scheduling conflict. That's an important distinction, showing the delay is procedural, not a victory for either side's legal position.
All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th.
The judge now delivers the practical consequences of the hearing. He formally rejects the filing because, in his assessment, it cites no valid criminal authority relevant to the case. More importantly, he sets famed deadlines and warns that failing to appear personally could lead to bond revocation and incarceration before trial. The focus has completely shifted from abstract legal theories to real-world consequences. So what do you think? Should courts spend more time addressing these arguments? Or is the judge right to move the case forward?
That's the judgment of the court. You need to take your piece of paper and go on about your business.
In the end, the court never accepted the attempt to appear through an attorney in fact, or the document challenging the proceedings. Instead, the judge reaffirmed the court's authority, denied the filing, scheduled new deadlines, and made clear that the defendant's personal appearance remained mandatory. The hearing serves as a powerful reminder that courtroom procedure and legal precedent often outweigh unconventional legal theories. If this courtroom showdown surprised you, let us know in the comments who made the stronger case. And don't forget to like, subscribe, and turn on notifications for more unforgettable courtroom drama.